Yes, Mr. Stone.
Thank you, my lord. My lord, I just want to finish off a point about the non-OECD countries by answering a question my Lord Justice Arnold asked yesterday. A paraphrase, which is how is it that non-OECD countries come to make contributions to the commentary?
Yes.
There is a document in the slim black folder that you were handed this morning. And if I can ask you to look at the fourth tab. What you have on the first page, just to show you what it is, this is part of the current condensed version of the 2017 commentary. And if you go down to page 92 of the bundle, you can see the heading Non-OECD Economies Positions on the OECD Model Tax Convention.
Sorry, where were you taking this?
So page 92, just to show you the heading, my lord.
Yeah, I see it.
And then if I could take it down to page 94 and invite the court to read for itself maybe the paragraphs 1 to 3, which set out the background for how the non-OECD members become involved. And you can see then below you see examples of the non-OECD members stating their positions on the articles or the commentary. Obviously Mauritius hasn't done so. I don't place any weight on this argument, but I just sort of answer the court's question.
Thank you.
It's always good to be educated. Thank you.
Every day is school.
And that is further explained. If I can just show you another passage from the current commentary at page 679 back in the main authority bundle, please. So it's at the end, tab 29, page 679. And we're in the introduction to the commentary, and what the OECD commentary is doing here is explaining effectively the role of the OECD models and the commentary. And if I can invite you to read paragraphs 9 and 10 to yourselves, please.
Yeah, but it's almost the same.
And then over the page, building on that, you see there's a heading, the influence of the OECD Model Convention, and paragraph 13 talks about the importance among OECD members. But it's 14 and 15 that I would invite to draw to your attention, my Lord, just to emphasise the role of the model even beyond just the member states.
Thank you.
So, my Lord, I was going to move on to look at the principles of treaty interpretation and look at the appeal through that lens. My learned friend showed you a number of cases of high authority on the principles of treaty interpretation. It's worth the court probably seeing the most recent highest authority, which is RBC in the Supreme Court. Many of the principles are the same and possibly not controversial, but it is right in my submission that the court has regard to the latest word on the subject. If I can invite you to go to page 610, please. You'll see at paragraph 26 that what was an issue in this case was the UK-Canada Double Taxation Convention. Just noting the date, you'll see that reliance is placed on later commentary about the Supreme Court in this case. We turn over the page to page 27. There is reference to the Vienna Convention, and Article 31 is cited, and the summary from the Anson is quoted in paragraph 28. And just as a reminder, the Court is concerned with the common intention which can be ascribed to the parties. It's to be ascertained by considering the ordinary meaning of the terms of the treaty in their context and in their light of the treaty's object and purpose. So here you are concerned with the common intention of the UK and Mauritius, and not simply the intention of one party to the treaty. And then turning down to paragraph 30, if I could invite you to read, please, paragraphs 30 to 31 reinforce the relevance of the commentary. And of course, paragraph 32 is the citation by the reference to Fowler, which I've referred to before. I also just want to look briefly, if I may, at the judgment of Lady Justice Falk in GI Financial Investments, with which Lord Justice Arnold agreed in that case. We can pick it up, please, at page 576 of the authorities bundle. And at paragraph 36, Lady Justice Falk repeats a summary of the principles that she gave in the Royal Bank of Canada and obviously in the Court of Appeal before it went to the Supreme Court. None of that should be controversial. Over the page at 577, please. You can see that there are some quotations at the bottom of 576 from Lord Reed, Gordon Anson, and Lady Justice Falk says over the page, he went on to emphasise in the same paragraph the Court's predisposition when faced with narrow and technical constructions to favour an interpretation which reflects the ordinary meaning of the words used and the object of the treaty. So we're focusing on the ordinary meanings of place of effective management. And then she relies upon the speech of Lord Diplock and Fothergill to support that point. The Lady Justice Falk adds some observations to that previous commentary, and could I invite you please to go to paragraph 43. Where she says this: fourthly, there was some discussion at the hearing about how reference to OECD commentaries, and indeed the MTC itself, fits in with the terms of Articles 31 and 32 of the Vienna Convention. Given Lord Briggs' guidance in Fowler and the fact that there is no controversy that reference is permitted, it is not necessary to determine the extent to which the power to refer to such material is derived from Article 31 or 32, or, at least for versions of the OECD commentary that postdate the relevant treaty, is akin to academic commentary. So the Court said there it wasn't necessary to decide the point. I would echo that it's not necessary for this Court to decide the point. So once it is seen that we said the later commentary is to be interpreted in the same way, as persuasive in accordance with its reasoning as academic commentaries would be. Then there was one further passage, please, which is on page 590. And it's paragraph 95. It's very much an obitive comment that Lady Justice Falk makes, because poem wasn't an issue in that case. But she says one further point to make on the Model Tax Convention relates to the corporate residence tiebreaker. If Article 4.1 of the Convention is considered from the perspective of the 2000 version of the MTC, then its use of the place of effective management as the tiebreaker also reinforces HMRC's interpretation. Essentially, it aims to determine the state with the closest real connection. Subject to the fact that you're looking at two states, is probably the closer real connection. It's the reality of the matter that I would emphasise, and is consistent with everything we've seen before about the need to focus on the reality where the management is effectively being carried on. So, my lord, with those principles of treaty interpretation well in mind, starting with the words of the convention, I know you've seen it, but could we please just return in the bundle to page 41 in the authorities bundle? And we have down towards the bottom of the page Article 4, and in Article 4.1 you see the connecting factors that would make a person resident include domicile, residence, place of management, or any other criterion of a similar nature. So the phrase used there is place of management. Contrast with the phrase in
I
paragraph
beg your
4.
pardon, I'm not in the
I'm
right
sorry,
place. Can you give me the reference again?
Yes,
It's
sorry.
tab 4, page 41.
Thank you.
And my lord, I simply draw the contrast between 4.1, which refers to place of management as one of the criteria, the connecting criteria, and 4.3, which uses the phrase place of effective management. And my submission that effective management, again, focuses on the substance and the reality of the situation, and immediately suggests a distinction between the two concepts. So those are the words of the treaty. Looking at the object and the purpose. Well, the object and the purpose of the treaty as a whole is stated in the preamble. And if we turn back to page 40, you can see it's stated there in the preamble that it is a convention for the avoidance of double taxation and the prevention of fiscal evasion. That is the overall purpose of the treaty. Looking at the purpose of this particular Article 4.3 that we're concerned with, clearly the purpose of that is to determine a single state of residence where a person other than an individual is resident in both states under their domestic laws. And looked at in the context, we know from reading other articles, for example, Article 13.4, that the purpose of having a tiebreaker is to determine which state has the right to impose different sorts of tax in different circumstances. So the very fact in my submission that you are looking at a tiebreaker between two states with either the same or different domestic tests suggests by itself that one is concerned to find the autonomous meaning of the tiebreaker rather than merely adopting a test from one or other of the parties.
Yes.
And then if we look at aids which my learned friend accepts are admissible, the 1977 commentary, I don't invite you to go back to it as you've seen it a couple of times unless you wish, but it that reinforces this point that there are a number of countries that have different domestic tests for residence, and it was in those circumstances necessary to choose one in order to break the ties between different countries, and the one that was chosen was place of effective management. Again, suggesting, in my submission, that there is an autonomous meaning that of this phrase place of effective management for the purposes of this treaty. And of course, the context being that this is based on the OECD model, which has got to deal with lots of different tests for residence in lots of different countries. Again, suggesting that the proper interpretation is to find an autonomous meaning for the purposes of the treaty. You also get from the 1977 commentary a rejection of choosing a formal test such as incorporation or registration. in favour, as it says, of looking at where the entity is actually managed. And again, I emphasise those words, actually managed. So that 1977 commentary suggests that you are not looking at matters of form, but you're looking rather at matters of substance to decide, when looking between two states in which the entity is resident, in which of those two states is it actually managed. And that will necessarily require you to look at the facts of both of the states in my submission, rather than looking at one state and asking whether the functions of a board of directors in one state has been usurped by somebody in another state. So, my lord, from those material, all of which my learned friend says accepts are admissible and proper starting point to construe it, in my submission it is very difficult to get from that a conclusion that the proper and only interpretation of poem is that you look at a board of directors or the constitutional organs, where the constitutional organs are at a point in time, and ask whether those decision-making functions have been usurped or dictated to. That is, as I've said a number of times, a rebuttable presumption in favour of one place being the country of residence, whereas the test of looking at where things are actually managed and the substance over the form suggests that you should phrase the test in a more positive way by asking the questions that the Special Commissioner said you should ask. Where is this thing actually managed? Where is the top-level realistic management decisions taking place of the entity that you are looking at? Moreover, a further source which supports my interpretation and certainly provides no support to my learned friend is the academic literature that we've got in the bundle. Of course.
Just before you do, one point that we aired yesterday, I think it was suggested that Article 4.3 looked to find the contracting state in which someone was resident, and there was reference to 13.4, again envisaging that you could only be resident in one contracting state. And it might then be said, well, that suggests whatever the test is, it has to be a test that yields one result rather than multiple results. I haven't been through the convention. Are there other bits of the convention that again point to one country where you're resident rather than potentially more than one?
My lord, yes. Maybe if I give you some of the references later on, but the short one is that the treaty is generally choosing or assigning taxing rights based on either the source or the resident of the person. And if it's going to assign taxing rights in the way that 13.4 does, it is to one country of residence. I will provide you, it's probably more efficient if I invite those behind me or next to me to give me the further references. But that does lead me on to one of the points made in the academic literature that I'll be looking at is that this is a test which yields one answer. And that is the better way of interpreting it. Now, in my submission, you don't need to get that from the academic literature because it is there in the words of Article 13.4 itself. There is no reference to if you can't agree, then you go on to a different way of approaching it. My own friend suggested that you get to map if you can't decide under 4.3. But as my Lord Justice Arnold may observe, there is no route from 4.3 into map. The way that, as it worked at the time, you get into map is that if a party considered that it was not being taxed in accordance with the treaty, then that party could start a map case. Article 4.3 has been relevantly changed in 2017 to make an express map provision. And although obviously I make no reliance on it, I can show you that very briefly because it in fact provides the context for then the literature I'm going to show you. If I could ask you to go in the bundle, please, to page 670.
This is the core bundle.
Sorry, this is the authorities bundle. And if I could invite you to read, you'll see this is the model taxation treaty as at 2017. And if I can invite you to read yourselves paragraph 3 at the bottom of the page. And if the court's interested to understand the reason for that change, is explained in the latest version, the commentary, and that's at page 728 of the authorities bond.
Sorry, which page?
Sorry, 728. So this is the latest commentary. I place no reliance on it for the purposes of our case, but it's just so the court has the full context. And if I could invite you to read paragraphs 22 and 23, please, to understand the change. It is helpful that you've seen that because, as I say, the academic commentary that we rely upon is Vogel. We've obviously put in the latest version of Vogel. That version postdates the change to 2017. The passages I'll show you are those where they comment on what the situation was like before 2017. I hope that makes sense. Vogel, of course, being one of the leading sources in this area. As has been said, the weight that the court places on academic commentary of the post-dated treaty depends on the cogency of the reasoning as well as the eminence of the jurist. You will find the Vogel chapter in the supplementary bundle of authorities. And I hope it is tab 2 of that bundle.
Yeah.
And the chapter is written by Professor Dr. Ismer and Katerina Blank. And if I can invite you to go, please, to page 86 of that bundle. And you can see subheading relevant factors above paragraph 134, and you'll recall from having just seen the new article that the competent authorities have to have regard to certain matters. And it says in paragraph 136, one of those has to have regard to is place of effective management. And it says the place of effective management, which is also mentioned in articles 813, 13.3, 15.3, 22.3, etc., is defined neither in the OECD and UN Model Convention nor in the OECD Model Convention commentary. As with the tiebreaker test in Article 4.2a and b, OECD and UN member countries, Model Convention, recourse to national law must not be had. Hence, poem is not to be confused with the place of management mentioned in Article 4.1, which has to be determined in accordance with the national tax law of the contracting states, e.g. central management control. And it says, though they may be factually identical, the place of management and poem serve different purposes and are to be interpreted differently.
I see that's attributed to one Avery Jones.
Seems to feature heavily in this case. While the place and management criterion in Article 4.1 is intended to describe one of the bases of unlimited liability tax with respect to persons other than individuals, the poem in Article 4.3 supplies the very important criterion to resolve cases of dual residence of persons other than individuals. And then over the page 137, the poem criterion is a factual test following the substance over form principle. And that echoes a submission that I've made to you on a number of occasions. And reference is made to the commentary, the key management and control decisions are necessary for the conduct of the entity's business as a whole. All relevant facts and circumstances must be examined to determine the place of effective management. And then what is said in the last sentence, even though poem serves as the tiebreaker criterion in most ETCs, there's no unanimity as to which facts are to be considered and what weight should be given thereto. So there is some uncertainty, but what do you see in paragraph 138, quoting from one OECD document, is that there are a very large number of factors that could be relevant in any particular case. So you see in 138, third line, where the directors meet to make decisions relating to the management of the company, where the centre of the top level management is located, where the business operations are actually conducted, where certain legalities have been fulfilled, such as the place of incorporation, the location of the registered office, the location of the public officer, where controlling shareholders make key management and commercial decisions in relation to the company, where the directors reside, where the headquarters of the person, what functions are performed there, and what is the relative importance of the functions performed in each of the two states. So that, again, reinforces my submissions that the court tribunal is concerned with looking at all the relevant factors and then weighing them up between the two states to determine where the place of effective management is. And if I could invite you to go to page 88, please.
Well, 139 seems to be of some interest, in particular because it addresses the situation you talked about, the directors' meeting held in two countries, poem located where the real control of the company is exercised, slightly curiously, a citation of De Beers.
Yes. And some of this confusion because that wasn't about her. Then at 140, there is some discussion about the point Lord Justice Newey just raised about whether poem resolves to one state or not. And there is discussion of some, there is some discussion of the point in 140 and other views being stated. But 4 lines from the bottom of 140, the authors of this chapter conclude, we nevertheless continue to believe that under the previous version of Article 4.3, and of course that's the one you're concerned with, there was only one poem, and that such poem had to lie in either contracting state. So you were forced to choose one or the other. It was a decisive test. If I could invite you to go please down to page 94. This is in the context, the subheading is above paragraph 116, it's called Divergent Country Practice, and it's dealing in paragraph 163 and onwards with countries that still have poem as a tiebreaker rather than the map that you've seen in the current version. And it said, it refers to Article 4.3 being used to establish poem's test as the tiebreaker criterion. Historically, the preferred criterion was considered specifically in connection with the taxation of shipping, etc., and you've seen all of that. 164, the criteria for determining the poem correspond to those mentioned in the context of Article 4.3.1. The function of the poem, however, is different under the tax treaties corresponding to Article 4.3 in their form prior to 2017, that's of course our case. The OECD Model Convention Commentary 2014 rightly asserted that the previous article the previous article with the poem as a single tiebreaker, that an entity may have more than one place of management, but it can have only one poem at any one time. And that is supporting what I said before, that domestically you can have more than one place of management. And then reading on, skipping line, makes the point the criteria admittedly leaves considerable leeway for interpretation, and then again you have a number of potential factors there. So it is not prescriptive, the poem test. It gives considerable leeway on the facts of any case to determine where actually the entity is managed.
And does it give any temporal parameters for measuring these factors?
Not that I'm aware
Not
of.
one way or the other, but
No.
yes. Oddly.
And then 166 over the page, please. 6 lines down, it says, thus, Article 4.3 in 2014 must be understood as stipulating 1, the existence of a uniquely defined poem, and 2, the location of such poem in one of the contracting states rather than in a third state. Given that poem has to be in either state, the provision has to be interpreted in that bilateral context. The economic connections, composed of all relevant facts and circumstances mentioned in the 24, the commentary, paragraph 24 of the commentary, to the 2 contracting states of a dual resident entity must be taken into account. Again, it's focusing that you look at all relevant facts and circumstances to determine, as Lady Justice Falk said, with which state the connections are closer, the real connection. In other words, the poem test is a preference test, which by its very nature must result in a definitive answer, either the contracting state or this contracting state or that contracting state. Arguably, there may be hard cases where the factual situation makes it difficult to establish which contracting state has the closer ties. However, such situations also arise under other articles, and those problems have to be resolved. And my lord, that as I say, is the leading commentary, academic commentary on this point, and clearly you would give it the weight that, as according to the cogency of its reasoning. Or I would make this observation, my lord, that it provides no support at all for my learned friend's interpretation of poem. It makes the point that the poem should not be interpreted in accordance with domestic rules. It suggests the poem is a much broader concept, having regard not only to the formal decision-making bodies, such as the board, etc., but also it mentions, as you've seen in the factors, decision-making shareholders. And it makes the point that you are required to choose between 2 states to identify where the entity is actually and effectively being managed. So in my submission, my lord, concluding, looking at this matter from first principles, the autonomous treaty concept of poem that you would be required to interpret requires a multifactorial evaluation of all relevant circumstances to determine where the key management and commercial decisions that are necessary for the conduct of the entity's business as a whole are in substance made. And it is a choice between 2 competing taxing jurisdictions. You use poem to identify that, looking at all matters in the relevant state. And that is, my lord, effectively what the Special Commission has concluded in Smallwood. That was the approach that they adopted. That was the approach endorsed by the Court of Appeal. And it's the approach that this FTT took in this case, on the facts of this case. And my lord will be aware that although the challenge is to the test that the FTT adopted, there's no challenge to the findings of fact or the inferences that it took. We reference in our skeleton argument paragraph 362 of the FTT's decision, where the judge sets out the key factual considerations that have led her to find that poem is in the UK. They are supported by key factual findings in paragraphs 363 and 364. And my Lord has already observed that there is a degree of factual similarity between Smallwood itself and in this case, not at all surprising because they were two iterations of the round the world scheme at about the same time, put in place through different advisors but effectively in the same way, because round the world scheme required certain steps to be taken in a certain order in order to achieve, as we say, residence in the UK and residence in Mauritius at the date of disposal. So, my Lord, I've covered those matters.
Thank you.
From Smallwood and from there. Are there any other matters that I can assist with?
No, I think you said you were going to deal with some various points that have been raised by Mr. Rivet, but I think you may have done that as you went along.
If I could just make one point, it was the, thank you for bringing me back to it, my Lord, but the point about the impact of the court effectively upholding the test that was used by the FTT. Because it was suggesting the Upper Tribunal there was some hyperbole in suggesting that there was fear running throughout the City of London about the impact of the decision. If that were a good point, it was a point that should have been made by reference to commentary or articles or actual evidence of concern, eminent people who are raising a concern about the application of this test. But as we know, my Lord, the test that was applied by the FTT was effectively the test applied by the Special Commissioners 15 plus years ago. Smallwood was decided in the Court of Appeal. There is no evidence of any negative impact to advisors in the city of the conclusions that were reached in Smallwood.
I think, as far as I know, we've just got no evidence one way or the other.
None whatsoever. And the submission effectively relies on a false premise, which is that the decisions of the Special Commissioners in Smallwood, the decision of the FTT in this case, were based on advisors in the UK being the ones who suggested steps. But that ignores entirely the decision makers, i.e. the settlors, being the ones who decided to put in place this tax avoidance planning by putting in place a scheme with the confident expectation of the sale. So to suggest that McFarlane's or Linklaters should be concerned about the impact of this judgment, I say, is simply unreal. And I repeat the point I made before, that we are concerned with entities that are dual resident. We're not concerned with offshore trusts that do not have UK trustees. We're not concerned with companies which are resident abroad and not resident in the UK. We are concerned only with this situation. And this is a particularly artificial situation in which a decision was deliberately made to have both Mauritius and UK trustees. That is why we're concerned with poems. So there is no reason to suggest that there is any broad application. You've already seen in the commentary that it records the cases of dual resident companies that are actually rare. And you've seen that that is one reason why they've moved to a map model, where for any situation where there is a dual resident company, they're resolved through map. So, my Lord, I hope those summarise the points I've made.
Richard.
So, you've taken us to Vogel. You haven't taken us to the other two documents that were in HMRC's supplemental bundle of authorities. There's the one at tab 1, Committee Response 2008, and there's the one at tab 3, which is about the Ottawa taxation framework conditions. Do we get anything out of that? And in any event, what are the Ottawa taxation framework conditions?
My Lord, that was my learned friends document.
Oh, sorry.
You asked. No, it was.
That's right. It's a composite bundle, was it?
It is. Yes. It was. I think, as my learned friend explained to you yesterday, they put it in because it was cited in a footnote in Vogel.
Oh yes, you're right. You did say that. I'd forgotten that. Yes. But what are the Ottawa taxation framework conditions?
I'm afraid, my Lord, I don't know if my learned friend has a book on the answer, so I don't know. Right. In my submission, one doesn't get much from that document. The purpose of the other document, I haven't considered it necessary to take the court to it, but what it does is it explains the change to the commentary that was made in 2008. As you brought it up, we can look at it, my lord. To tell you what the change was, there was a sentence to the effect that ordinarily, actually, I shouldn't paraphrase. Go to the authorities bundle, and if I can invite you to go to page. Yes, if I can invite you to go, please, to page 666 in the bundle. Actually, the better place is paragraph 658.
Sorry, paragraph 6.
Sorry, page 658 of the authorities bundle.
Sorry, I wasn't keeping up. Which page?
Sorry, my lord, 658 of the authorities bundle.
658.
It's tab 26. My Lord Arnold, if you see in the middle of paragraph 24, there is a sentence that says the place of effective management would ordinarily be the place where the most senior person or group of persons, for example, board directors, make this decision, the place where the actions to be taken by the entity as a whole are determined. However, no definite rule can be given and all relevant facts and circumstances must be examined. Then in 2008, the commentary was changed, and we see that at page 666. And effectively, that sentence is removed, so it after the second sentence, it goes straight into all relevant facts and circumstances must be examined. So the sentence about ordinarily being the board has been removed.
So we got into this because my lord's question about the Ottawa taxation.
No, it was a different question.
We moved on. There we are, Mr. Beat.
And that then takes me back to that.
Sorry, I'm struggling to find the reference on 666.
So in 666, you don't see the sentence that was there previously, is the short point.
So it's paragraph 24.
Yes, there was
as a result, and you're saying the sentence.
The sentence that says ordinarily this will be the board of directors has been removed.
Right. Oh, I see. Right, yes.
The document that my Lord Arnold asked about explains that removal. So if I can invite you to go to that document as page 3 of that supplementary bundle. And the relevant sentence is the one 4 lines down underneath a subheading changes to the commentary on Article 4. Mm-hmm. And the sentence says, as acknowledged by this commentator, however, his suggested draft was based on the approach put forward in the discussion draft, etc., which had been released in 2003. That approach had been rejected by the committee because for many countries it gave undue deference to the place where a board of directors would meet, as opposed to the place where the most senior executives of the entity would make management decisions, which is the main reason for the change made to paragraph 24. So this is an OECD document which is explaining why that change was made, and it's because undue deference was given to the place of the board of directors.
Thank you.
Okay. Mr. Stone, thank you very much. Yep, hang on.
Sorry, for 1 moment, just
yes.
References from Lord Justice Newey. Will you just give me 1 moment?
Yeah.
My lord? there's a so Lord Justice Newey, if I could invite you to go to page 44 of the authorities bundle, please.
Yep.
You see the reference to shipping and air transport, and we've seen reference to that already in the commentary on Article 4.3. So profits from the operation of ships or aircraft in international traffic shall be taxable only in the contracting state in which the place of effective management is situated.
Yes, I see.
Sorry, where is that, please?
Sorry, my lord. It's Article 8.1 on page 44.
Thank you.
My lord, maybe if I don't want to take on my own friend's time.
But anyway,
I'll
there's
just
one
check those
further.
references.
I'm sure there's no problem if you find others, if you
no,
email them in, then
Thank you, ma'am.
because we're not going to give an extempore judgment this afternoon. Yes, Mr. Rivet.
My lords, if I might start with just two general observations
Yes.
in relation to my learned friend's case as advanced before the court today. The first is one which goes to meeting the point regarding the wider significance of this case. I hope it is not inappropriate to say to your lordships the following. At some stages over the course of my learned friend's submissions, we traversed some ground which is occupied by some pretty sacred cows, which are fairly fundamental to the operation of the English tax code, particularly the effect of the test for central management and control. Now, I may be wrong that that is not the test of Perm in these circumstances, but at some stages, submissions were advanced as to what that test is and how it should be interpreted. I mean it with no disrespect to my learned friend, who's a fantastic advocate, to say that it is one thing in circumstances where this court is called upon to adjudicate upon the meaning of a treaty which was agreed in February 1981 between two sovereign nations and laid before Parliament and agreed and delivered by the court in Privy Council in July 1981 as to the meaning of Perm in the context of that treaty. What I'm slightly nervous about, and I hope this is not in any way meant to derogate from the importance of your function, is that through a sidewind, something comes out which affects the meaning of central management and control for these purposes. And I don't mean that in any way with any disrespect to my learned friend, and certainly not to this court. But clearly, people.
No, well, it's a wise caution to offer,
it is
because inadvertently, in focusing just on what we're doing, we may say something which is then taken up and used in a context which we had not been addressed about or thought about.
I'm grateful, my lord, and in due course I will develop that in a little bit by reference to the submissions I make regarding the nature or absence, as I will put in due course, of a test that is articulated by my learned friend. Because, for example, in the context of both Poem and indeed in the context of CMC, there are questions that taxpayers and HMRC alike need to make by reference to objective criteria capable of uniform application as to in what circumstances they will or will not be resident and at what time. To give you an obvious illustration of it, my lord, you'll be very familiar with the fact that the terms of the English Code for companies impose an exit charge in circumstances where you cease to be UK resident. Now, in circumstance, the reason that the courts have over years laboured to lay down principles as to articulate the circumstances in which a company will or will not be subject to central management and control in England is precisely so that HMRC, taxpayers and the courts and business can identify what the consequences of their action will be in particular circumstances as to where they will be held to be resident. And that has nothing to do with tax avoidance or otherwise. It is a fundamental feature of the nature of our law. In a sense...
well, not just our law, any law.
Exactly.
I mean, this is the old debate of standards versus rules.
Exactly, my
I
lord.
mean, a rule would give you a precise answer, which is totally predictable, but it allows for no flexibility. Standards give you more flexibility, but inherently are less predictable.
Yeah, my Lord, I absolutely endorse that. Indeed, I think we saw a rather
But this
good
is a
example of
standard.
Lord
It's not-
Radcliffe's
this is
judgment.
plainly a standard. It's not a rule.
It's
It's not you speed if you exceed 30 miles an hour.
No, I accept that, my Lord. But if one remembers the judgment we looked at this morning, and I will take you back to, if I may, in Unit Construction and Bullock, the point that's made by Lord Radcliffe was, look, in some ways, life would be an awful lot easier if Parliament enacted a rule which said if you are incorporated in England, you're resident here. Indeed, it has done that subsequently. And he makes precisely the same point, my Lord, and says that the best we can do is that which we have from De Beers. And if I may, I'll come to that in due course.
But I mean, we have this debate constantly in the law. I mean, negligence is another example. I mean, negligence is a standard. And of course, case law over the years provides guidance, but it doesn't provide a unique answer.
And I accept that, my Lord. But what case law in the companies, in the central management and control context does do, is to lay down the circumstances in which you will have central management and control in one place or another. And as new facts come up, it is possible that a new category may be identified. We'll see that from Lord Radcliffe, in fact, in Unit and Bullock in a moment, in a passage which we didn't look at this morning. My Lord, of course I accept that. But if I may, I make the point as a matter of general observation, both as I hope by way of modest submission as to quite some of the stakes that lay on either side of the path in this case, but also by way of observation that with the skill of a gifted advocate, we have been deflected from our task, which is actually the construction of a treaty that was agreed to parties at a particular point in time. And that quite a lot of the time, with respect, and I'll make this good in due course, what my case proceeds upon the identification of the test that was agreed between the parties and made manifest and enshrined in the terms of that order at that time, and was laid before Parliament and approved on that basis. And my learned friend's case at times answers that by saying, well, as a matter of general principle, this isn't very desirable because it might lead to two answers, for example. Well, even if it was a bad test, that's not, with respect, the question. The question is, what do these words mean in the context of the treaty? And if I might, with respect, make that point good by reference to my criticism of the absence of test standard, however it is described, in Smallwood, but also in the context of my learned friend's case. You have heard two iterations of the way in which the test or the standard, even this afternoon, is articulated by my learned friend. The first is that when the gauntlet was laid down by me at the outset of the day, I thought that what my learned friend had hung his hat on was the provisions of paragraph 130 of the terms of Smallwood. And if we could turn that up, please. I had thought that HMRC's case, having been had this, I put this point below as well, said what is your standard or your test for measuring this? I thought that my learned friend yesterday, I had understood to adopt the formulation at the end of 30. Accordingly, there's nothing in this additional material that changes our initial review, having regard to the ordinary meaning of the words in their context and in light of their object and purpose. We would approach the issue of perm as considering in which state the real top-level management or the realistic positive management of the trustee qua trustee is found. Now, I'll come to that in a moment. But that wasn't where my learned friend just ended. What my learned friend just ended by saying was that the test was a multifactorial evaluation of the circumstances in which it was based. And that's saying there isn't a test. You just look at all the factors. That's a different thing.
I didn't, you were perhaps listening more astutely, but I didn't think they were mutually exclusive. I thought he was describing what you do to see whether the test is met, what you look at. You look at a range of factors in deciding where the real top-level management or the realistic positive management is.
But in those circumstances, I need, with the greatest respect, to remind myself of the fact that in the context of the Wood and Holden line of authorities, one needs to articulate where the touchlines are drawn.
Yes.
Which factors do we take into account, and over which time period? And from where do I divine what the intention of the parties was, as at the time at which the poem test was agreed? And with the greatest respect in the world, that remains at large for my learned friend's case. And that is my criticism of it. And whether it is described as a test or a standard, it is incapable of uniform application at the moment. And I make my submissions in the context of the treaty that was laid before Parliament and made in 1981 in July, because that is the case that is before this court. But clearly, and indeed as a vote, we'll look at Vogel in due course, which says the same thing. It's quite possible, and I said this at the very outset yesterday, that different parties to a bilateral treaty might have looked at different things. I have to accept that. That's the logical corollary of my case. But interestingly, this point and my criticism with the case of HMRC is actually a dividing line that's illustrated quite vividly in the passage that you were just shown by Vogel, if I may respectfully ask you to return to that. So if we go to the Vogel passage that we were just looking at, which I believe is in the supplementary bundle that we've been looking at.
Tab 2.
Yes, ma'am. And we were looking, I believe, at the terms, we were looking at the passage regarding place of effective management from 136 to 141. Now, just to put this in context, I'm not making submissions about the relevance of this commentary or about its admissibility as a mean to construction or otherwise. All I'm seeking, if I may, to illustrate is that what you've been given is a synonym, if you like, for the language which is baked within Article 4.3. You have not had a test or whatever, however one formulates the response to that, as to what the pitch is within which you answer the questions as to where that is located. And Professor Vogel spots the distinction between these two different things. Because in the first place, there's a series of passages that are given as to what's meant by the place of effective management. This is obviously later than our treaty, but he draws a distinction between what the place of effective management is here. But then he says, look at page 137, all facts and circumstances must be examined to determine the place of effective management. However, no further guidance is given on its meaning. At that point in 379, the footnote is to my Ottawa document, to which I referred this court yesterday. And that was the passage which refers back to, you'll recall it, we looked at it, I can turn it up again if you like. It says, look, some people apply central management and control as the test for this. So that's the first point to make for me. The second...
That's inevitable in circumstances where you've got no supranational court to interpret.
Exactly, my lord. That was why I wish you were the court
So
of
no
France.
national court, us included, can solve that problem.
Yes, my lord. Yes, my lord. Absolutely. And I'm inviting you to do so by reference to the test that I've put into my skeleton argument. The problem is that at the moment I do not know.
But your test isn't a rule either.
It is not a. Well, my lord, it is as much of the standard as one may take from the Court of Appeal in Wood and Holden. What Wood and Holden says, and we can come back to it in a moment if I may, my lord, is, look, in circumstances where you have a tax avoidance scheme, and there's lots of advice given in London, and in which a decision falls to the Netherlands to be made, it's not the tax advisors or indeed the shareholders who make the decision as to whether or not to do this thing or otherwise, unless that position has been usurped or instructed, to use my Lord Justice Newey.
But that's just rewriting the language of the statute. The treaty. The treaty says place of effective management. It's inherently imprecise. It has to be applied to the facts of the case.
My lord, but then if one looks...
It doesn't say look at the constitutional organs unless they're usurped. It just doesn't say that.
Well, my lord, may I come back to that? Because actually, what I will submit in due course, that having regard to the proper means of interpreting the terms of the 1981 treaty, the sources that were available to us at the time, that is precisely what the UK understood that to mean. Indeed, I will also make...
How can the unilateral understanding of the UK have any bearing on it?
Well, this is the point that Dr. Avery Jones makes, because Mauritius may be taken to be aware of that, not least because precisely the same test was included within the 47 Act, and I'll come to this in due course if I may, my lord. May I just show you one other point before coming back to this, and I will, my lord, Lord Justice Arnold, I'm anxious not to...
Just briefly going off on a tangent. the next footnote.
Exactly.
Oh, I see. Reference to with respect to the impact of corporate governance system on the poem concept in Spain, France, the United Kingdom, Netherlands, Germany, and Italy. And somebody's written about it.
Oh yes, lots of people have written about it.
Yes, I see.
But the point that my Lord Justice Arnold says, I think I took his comment. If one looks onto the next bit, as for placing weight on such relevant factors, we then go into, so the test is that, how do we identify what those factors are and what weight we play upon them? With respect, although I quite acknowledge what I believe to be my Lord Justice Arnold's point, the footnote identifying the directors refers to De Beers. I understood Lord Justice Arnold's point to be that's not De Beers, that's Swedish Railway. But the point remains the same, that they are referring to the line of authorities dealing with central management and control in resolving those questions.
Just picking up another tangent briefly. Wood and Holden was a company case.
Yes, it was, my lord.
Smallwood was sort of a company case. It was a corporate trustee. I mean, it wasn't acting for itself. It was acting as a trustee, but it was a company. So Wood and Holden had an obvious potential application. Here, we don't have we have a corporate trustee, but we have two trustees, one of whom is an individual. The decisions are made by the trustees, presumably, not by the company.
Well, my lord, this comes back to the terms of section 69, subsection 1. And the first thing is, if you remember the second limb of the terms of section 69, subsection 1, general administration of the trust is one aspect to it. Then there's the question of the residence of the trustees. So in resolving the question as to whether or not the trust company was itself resident in Mauritius as a matter of general principle for English tax purposes, one would look to central management and control. When it came to the question as to whether or not Mr. Chandra was resident for the purposes of that, you'd look at the individual test of residence for those. But as with any corporate, companies are not yet automated in their decision-making process. Human beings sit on a board of directors properly constituted, or sometimes not, as we see from the authorities, and make the decisions on behalf of those companies. So at some point, you are always going to have an examination of individuals, because a company is entirely a creature of law.
Well, that's obviously true, but I don't quite understand the relevance of it to my Lord's question, where we have two trustees, one of whom is a human being and is not a corporation.
Well, the first, just as a matter of, if I may, and that's a point in relation to that, that individual was also, as it happened, a director of the corporation.
But he wasn't.
Yeah, let's assume. I'm not sure. I'm not sure that takes us any further. But I think the point that my Lord Justice Arnold is I think pushing me on is, well, those submissions of Mr. Prosser, in which he adopted the Wood and Holden test, was that a clever means of indirectly, given the terms of the pleadings in which they went up to the Court of Appeal, advancing CMC as a mechanism by which to, through the back door, effectively. And Mr. Prosser is an extremely gifted advocate. It's not impossible. But my point is put squarely on the former point, that actually, in the context of the treaty you are called to construe, the parties thought, and the meaning from those words, that the test for the place of effective management was the same as the De Beers line of authority. Yes, I'm reminded, my Lord, just to make good the point I was making about, while we're on this, it's slightly out of sequence, but can we move to Ottawa just for a moment to make good a point I made in passing just a second ago? And this is the source of Vogel's point. If one looks at page 107 of the bundle that's before you, this is the Ottawan passage that was handed up.
But, sorry, in the way of academics, it provides support for a statement that needs no support. Because the statement made is blatantly obvious as soon as you look at the treaty. All it's simply saying is you don't get any guidance out of the treaty as to how you apply this test,
Well,
which is a statement of the blindingly obvious.
well, my lord, but if you look at the terms of page 107 of this, sorry, 106 is the starting point of it. The question that's posed to itself in the context of this document.
So 106 of what?
106 is the supplementary bundle, tab 3. The one
the
to which
Ottawa.
we've added, as it were, over the last couple of days. The one that now has 9 tabs, which is a blend, an unholy blend of our supplemental bundle and HMRC's.
And the benefits from balance.
Thank you, my lord.
So 106.
And this is the source of 4 of the footnotes that are relied upon by the Professor Vogel, upon whom my learned friend relies upon. So I fully accept the point made against me by Lord Justice Arnold, that in a sense there can be a self-serving element to academic commentary, with no disrespect to those involved in that exercise. But here, the very precise question that is asked is, how do you determine a place of effective management in a traditional environment? This is the source of Professor Vogel, who's held up as the expert of this, his opinion. The meaning is not defined in Article 4, nor is any further guidance given at the end of 145. In the absence, it says on 107, of any specific definition of place of effective management, many commentators have been influenced by concepts using domestic law residence, such as residence, central management and control, and considering the meaning of the term place of effective management. And they go on.
Sorry, you seem to have skipped over the paragraph which is actually the source of the footnote, which is the bottom of page 106. The term place of effective management not defined in any articles mentioned above, nor is any further guidance given on its meaning. That's the statement that's being cited, and as I've said, it's a statement of the blindingly obvious.
I agree, my lord. We wouldn't be here if it did. If it said in the Mauritian treaty, we're applying CMC for this, baked into the treaty itself, my lord, one would be watching the cricket. But it isn't. It doesn't say that, and that's why Dr. Avery Jones, and Dr. Bryce, the special commissioners in Smallwood, have to grasp around to give some content to the meaning of Article 4.3. And the question before this course is, what are the sources that you should use to construe those words in the absence of any, and not in some objective Platonist words of what does this mean in the abstract? Professor,
all right, but where's the bottom line? Because where you were reading from, top of page 107,
yes, my lord.
Says, in the absence of specific definition, commentators have been influenced by concepts used in domestic tax law, and one might have, such as CMC, and one might have thought that was inherently a wrong approach. But having trotted through the various factors that people have looked at, the authors of this document conclude at 109, place of effective management will generally be where key management and commercial decisions necessary for the conduct of business are in substance made and given.
Yeah.
Which seems to me at the moment to be 100% consistent with Mr. Stone's case.
Well, but then we're in a Platonist world, my lord, as to what the right test is as a matter in the abstract. What I'm concerned with is what was agreed between the parties and understood in terms of the 1981 treaty. That's the case before the court. And it's possible, as Professor Vogel identifies, that different states, different bilateral agreements might have different interpretations of this. But that is why those passages from the court in Anson, which keep repeating that you're applying Commerzbank principles in construing the terms of a treaty, are so important to this. And in my favour, I'll come on to develop this in due course. I don't just rely upon this makes sense, common sense, the CMC test. In fact, I would make my submission even if it didn't make sense as a matter of general principle. As it happens, I think it does. But I would make the same submission even if I thought it was a bad test, precisely because the context of the 1947 treaty, the terms of the commentary which recorded the United Kingdom's position in relation to it, and conspicuously the statement of practice issued some years after the event, which identified that was how the EU came there, are all consistent with my reading of the terms of what those words mean. And one thing, and it is not a criticism of my learned friend, I've been on that side of the room enough to know, they have very difficult decisions to make all the time. One thing you did not have from the other side of the room is a statement as to what the UK thought those words meant, as to whether or not that statement in 1981
It
meant
would be
that or not.
inadmissible.
It would be. Yeah, exactly. I would say it was inadmissible, even if it did be. But, my lord, funnily enough, my lord, that's a submission I made yesterday against Dr. Avery Jones's, the Special Commissioner's judgment in Smallwood. There's all sorts of bits of evidence floating around there which would be inadmissible in ordinary circumstances as to what the meaning of the test is. Oh yes, my lord, just while we're on this, before we move on from it, I'm asked to show you the top of page 110. It simply states, just to finish off from those summary of it says key factors in determining the place of effective management. It goes through a list of things that it thinks is those, and it says at the top of the next page, it should be noted, while the guidance and central management and control in the place of management indicates the place of effective management would ordinarily lie with the directors. In certain cases, these strategic decisions and powers may be elsewhere.
Yeah, the last paragraph in that section is also quite interesting because it talks about revolution in communications technology and people being physically in different locations. And the conclusion, this increased mobility and functional decentralisation may have a significant impact on the instance of dual resident companies and the application of the place of effective management tiebreaker rules.
Yeah. My lord, I completely accept that. Indeed, that's a point that my lord, the Lord President makes repeatedly. I think it's absolutely right. But the OECD aren't blind to this. It's for precisely that reason, one of them, that the terms of this treaty, the model treaty, have been re-agreed. The departure point is not that poem is the tiebreaker, it's that you have a targeted map.
That's much later in time, though. This is back in 2001.
Well, my lord, this is back in 2001, but even then, prescient. I mean, that's a long time after 1981. But in any event, I'll come on to address this when I deal with the Swedish case, if I may. But I'm under no, I would not want the court to think that in any way CMC is perfect. But I don't need to go that far. I just need to go to demonstrate that that was what the parties understood that to mean at the time they agreed the treaty. And put slightly differently, if my test isn't perfect, then goodness no, with the greatest respect, HMRCs will just look at whatever you like. That's even worse. Indeed, it's a criticism that I will make in due course of the approach that's urged upon the court by His Majesty's Commissioners, that what I believe their standard or measure of what is meant is by poem would be vulnerable to precisely the same criticisms that they advance against my test of it. Particularly if you take, for example, the vivid facts, insofar as you know what the facts are, of the Swedish case. My lords, what I was proposing to do is, I think that those are my assault as a matter of principle, as it were, on what the test is. I've made my points regarding the contemporaneous materials in relation to it. I'll develop the 47 treaty in due course when we come to Sweden. But I would just anchor this point in some other things. The other points that with respect, I don't think have really been fully addressed by my learned friend's case, which is that the point is made, this is a treaty which has an autonomous meaning in relation to it. But then, at a number of points of time, submissions are advanced that aren't autonomous treaty meanings. And a very good, vivid example of this, and I really mean it with, I have to be careful how I approach this submission. Could I ask you, please, to turn back to the terms of the Smallwood judgment in the Court of Appeal? And in particular, to the judgment of Lord Justice Hughes. I'm not at this stage addressing the question as to whether it's binding on you or otherwise. I'm simply looking at where the touch lines are drawn as to how we identify where the place of effective management is given. Now, I thought the submission was advanced, with which I agree, that we must give an autonomous meeting to the terms of the bilateral agreement between the two states. And that being the case, which I wholeheartedly agree, the domestic meaning of it can't affect it. But you've heard my submission that the mere fact that CMC is used to solve one problem in England does not mean that it is incapable of solving a different problem under the terms of the treaty. And I will make good the fact that it does so in a number of circumstances. The difficulty where my learned friend's case breaks down is that when the court pressed him as to why it was that the Court of Appeal rejected Wood and Holden as being the test in the context of that decision there, it gives you a very, I believe to be an answer. There's a temporal answer, not to do with the quality of the decision making, but actually in the first instance, a temporal answer. What is the mandate for looking at these decisions? And he says, well, the answer to that is found in Lord Justice Hughes's judgment. It's section 69 of the Capital Gains Tax Act. But then my learned friend is in trouble, because that is not part of the treaty. That is the exact opposite of what one has to do to construe the meaning of the words in Article 4.3. And that is exactly the point that's addressed by Lord Briggs in Fowler, where he says, you can't resolve what's meant by employees or otherwise in the context of a treaty by reference to some fiction that applies as a matter of English law for domestic purposes. They have an autonomous meaning. And so if the answer is the mandate that Lord Justice Hughes found himself to have to depart from Wood and Holden is to be located in section 69 subsection 1, then with the greatest respect, that cannot be right. I will make good this point in a moment, but I think out of fairness to my friend, as it happens, I do not believe the facts are an issue in this case. As I think I said at the outset, if I'm right on the test, I win, and my learned friend loses. There's no respondent's notice saying they win if we're right on the test. Likewise, if my learned friend is right on the test, I lose, and I accept that. But in fairness to my it was suggested, I think, this morning that, as it were, this was a quick trip offshore. That is not the case with these settlements. These are long-standing settlements that were located outside the UK. They were only in the UK for a small period of time after the Mauritian period had ended. What must be necessary? My learned friend is not saying these trusts were the place of effective management in England was because the trustees came back to England for the second half of the year. He is saying that they were effectively managed in England because the settler and the professional advisors were in England. That's what he's saying during the Mauritius period. So I hope I've made my point about section 69, subsection 1. If that is the mandate that is taken to be afforded by Lord Justice Hughes to rejecting Wood and Holden as to the focus upon the particular decisions that are made by the trustees during the Mauritian period, with the greatest of respect to my learned friend and to the exceedingly eminent judge, that can't be right, given Fowler.
And there's a further difficulty, it seems to me, about Section 69 and Lord Justice Hughes' reliance upon it, is that I don't think it surfaces in the reasoning of the special commissioners.
That's, my lord, that's exactly right. And indeed, I think that, with the greatest respect to the special commissioners, they were on to the point that really, I think I said yesterday, one of the difficulties with this case, and Mr. Brennan, I should say, by the way, I hope it's not inappropriate to say so, he was a greatly missed man.
Oh, well, I only knew him in context outside of the courtroom, and I see his name in the course of the last 2 days, and remember him with great fondness.
Yeah, he was very good to all of us, not least, I know, my learned friend, but I hope that's not inappropriate to say that.
No. I think it is appropriate for you to say it, because he was on the other side, and so that's well said.
But Mr. Brennan was wrestling with this at the High Court in Smallwood, because Dr. Avery Jones, the focus of the part of the argument was on the snapshot from the moment of alienation. And I'll come on to this in a moment, because it addresses a point that my Lord Justice Arnold has been making about this, about the treaty. What does the treaty tell you about the time at which you test this? The submission is rejected by the court in powerful terms albeit with the dissent of Lord Justice Patten as to the snapshot approach in relation to it. But if you recall...
Sorry, Lord Justice Patten agreed.
Sorry, agreed to the snapshot. Sorry.
They were unanimous on
the
that
other way. I'm so sorry, my lord. I meant in the point I'm advancing is, if I think I showed it to you yesterday, Mr. Brennan's case before the High Court, when wrestling with the question of how on earth do I test the place of effective management, was to say, well, for Poem, by contrast with the test of on the first limb of the argument, you do test that at the moment of the disposal. And that's rejected, or it isn't really addressed by Mr. Justice Mann, who doesn't need to deal with it. But that's the case before the High Court. And Mr. Brennan was very live to this. The focus of the argument was on the snapshot at the first point, but there is not, with respect, there's no, the judgment of Lord Justice Hughes doesn't explain the argument as to why, as it were, as to what the temporal period or canvas is that you're entitled to test Perman for these things. And I am nervous, given the points that have been made regarding my ability to disturb points that are made on the part of the Court of Appeal. But I think it is right to register that one of the difficulties with this case is an articulation of how, at what point you test this. If I may, simply to answer a point that my Lord Justice Arnold has made this afternoon, if one returns to the terms of the treaty, if we could, and you'll find this in the core bundle. And Article 4, subsection 3, this is not on this submission, but just what it occurs to me. I don't think my learned friend went so far as to suggest that there wasn't a map procedure in circumstances where the tiebreaker failed for 4.3. With respect, that can't be right. That's not what Article 27 says. I don't think I need to take the court to do it. It's perfectly clear that it's talking about the application of the treaty. So it would cover that, and I think most people would be quite surprised if you couldn't have a map procedure on residence in the context of this. If that is what he's saying, and that's the revenue's position, then there we are. That's what you're saying. I'm grateful, very grateful for the clarification. So there was a map procedure that applied to this as well. I'm most grateful to my learned friend. So the first thing is, Article 4, read in isolation, does not, of course, give you an answer to this. My Lord, this is the point that I was making at the outset yesterday when I said that different countries have different basis periods as to when you test things and when you measure things. What we are concerned with is, what is the effect of residence upon the allocation of the taxing rights under the capital gains tax article? And if you look at the terms of Article 13, if I didn't have the JCB of Smallwood in my path, I would be saying, well, look at the terms of subsection 4 of Article 3.
3? Okay.
13, I apologize.
13.
Sorry. Article 13, subsection 4. Capital gains from the alienation of any property other than that mentioned in paragraphs 1, 2, and 3 of this article shall be taxable only in the contracting state of which the alienator is a resident, and that if one is forced to identify a moment in time at which one tests it, it is at the point at which the disposal is made, or the alienation is made for those purposes. Now, as I say in the test that we articulate in paragraph 36 of our skeleton argument, I fully accept that there may be circumstances in which, despite the fact that you are testing the quality of the management at a particular moment in time, there may be facts before and conceivably afterwards that bear upon whether or not the management was actually being done by you. And with respect, that I think is what is going on in Smallwood. Because in Smallwood, if you remember that both parties are agreed as to the critical findings of fact that were made on this. The findings of fact that are in effect made by the Special Commissioner is that the decision to sell the liquid set of securities there in question, which were marketed securities, had been made before the Mauritian trustees were appointed. The decision that remained...
Sorry, are you taking issue with the point that Mr. Stone made, that the double tax treaty does not change domestic tax law as to the basis of taxation, viz. That it's by reference to the tax year and that you can have taxation as a result of disposals within the tax year, even if there is residence for domestic purposes only in a single day.
Well, my lord, I think, with respect, I think that's a function. I think that's a submission that's made about the effect of section 2.2. And what 2.2 says, if you're resident at some point in the year in English terms, as a matter of domestic law, and there's nothing in the double taxation agreement which affects that conclusion, then you're chargeable to tax for the whole year. So if you're resident in Mauritius during that year, but not resident in the UK, as a matter of domestic law, you're okay. If you're resident in Mauritius, but not in the UK, as a matter of double taxation convention law, which is incorporated under the provisions of section 788, then you're okay. Where you're in trouble is in circumstances where, that sounds pejorative, but I apologise for that. Where you are paying the tax, where you are caught by section 2.2, is in circumstances where, as a matter of either domestic law or the treaty allocates, it says that the UK can tax you, in which case the fact that the disposal happens in, if you like, June in English terms, but you're actually managed, you're not managed in, you're managed in England, and you happen to be in Mauritius only in June, but you're managed in England for the rest of the year, then you're caught by it. I'm worried that I'm not answering your question, my lord.
No, because my question was, are you taking issue with what he submitted? I think that the answer to my question is no, but I'm not entirely clear.
Well, I think it sounds as if it's rather important that I'm clear on this, my lord, that I'm clear with you as my answer on this. I am absolutely clear that the terms of this treaty have an autonomous meaning.
That you're agreed on that?
Yeah. Well, I'm agreed that's right. I say that my learned friend's case relies upon him saying it doesn't have an autonomous meaning, but we're agreed that it should have.
His submission is diametrically opposite to that. He agrees with you that it has an autonomous meaning.
Yeah. So,
but that wasn't my question. My question is, do you say that the treaty changes domestic tax law and the way in which its general architecture?
Oh, yes. Yes, it must do. The treaty must change it. That's what 788
So
says.
where do we find the reference to the tax year in this treaty?
But you don't. My lord, I'm worried that I'm violently agreeing with you.
There may be cross purposes. I think you need to clarify.
It is perfectly clear from the provisions that I hope I took the court to yesterday in 788. Subjects' rights in England incorporate, as a matter of domestic law, both those which are conferred in the domestic context, but also those that are allocated under the terms of a treaty, as made manifest in an order of Parliament. Now, I can look at either my rights as a matter of general principle, or if something in an order such as this disturbs it, then that's fine. There is nothing in this order which tells me what the tax year or the period is, or otherwise, and that's why I say, when you have to look at the time which you test
can't change domestic law in that regard.
Very much. It couldn't. It could do if, for example, the terms of the treaty said to avoid
tax year runs from 1st January to 31st December.
Then
it could do, but it doesn't.
It doesn't do that. No, it doesn't do that. And that's why this is the point, I believe, in my favour, my lord, at saying that the only indication you have as the point in time at which you test this is the point of alienation. What my learned friend needs to do is to say, well, you don't test the term of alienation under the terms of the treaty for seeing whether you are resident there or otherwise, because I want to read Article 13.4 as saying that I can test place of effective management throughout the course of an English tax year. And that's not what it says. I think it turns on section 2.2, my lord, of the English provision. My lord, I absolutely, so that you're square to my position, it would in theory be possible for the parties to a bilateral agreement to agree, for the purposes of a treaty, an autonomous tax year. It could do that.
Of course they could.
Yeah.
But they haven't.
They haven't. No. But what they have done here is, and in a sense, I worry that I'm fighting a point that is not necessarily a point that would take. My basic point is, if the mandate that is taken by the Court of Appeal in Smallwood for departing from the CMC test from Wood and Holden is section 69 of the Capital Gains Tax Act, that can't be right with respect.
Can I just at the risk of confusing everybody further, take it,
I'm not sure that's possible.
take it forward. So Article 4.1 of the treaty
Yes, my lord.
Talks about a situation where you are liable to tax by reason of, among other things, residence.
Yeah.
So that ties back to Section 2 of the Act. You are liable under English law for tax as a result of residence.
Yeah.
And we assume that you are also liable under Mauritian law on a similar basis. So that potentially you're within Article 4.3,
Yes, my lord.
which is what we're all arguing about. Then you say, well, 13.4 identifies the point at which you're supposed to be asking the question.
Yes. I don't need to
And
do
that
that.
talks about...
So this is back to the snapshot approach, and where is that in your ground
Yes.
of appeal?
Well, my lord,
I think
I hoped I had made clear yesterday, and I made it clear again today, and it's in our skeleton argument. I accept I cannot challenge the snapshot approach.
Yes,
before
Don't
this
we need
court.
to, in
Put it in my
the
skeleton
discussion
argument.
that we've
Yeah,
got
I just
ourselves, don't we need to stand back and realise that Article 4 only applies if two residents,
yes, my lord. Yeah.
you're resident in two jurisdictions, and so reference to the tax here, we're only looking at the tiebreaker because there are two horses running.
Exactly, my lord.
And so the fact that you are resident in Mauritius on a particular day, in this context, doesn't answer the question because there's a second
It's
residence, and I think we've got ourselves...
into a challenge. But I hope, I just am anxious that my Lord Justice Arnold doesn't think I'm cheating. I'm absolutely clear I cannot revisit the snapshot before this court. And we put that in our, that's in our skeleton.
And well, you've been plain on that.
We've reserved our way the whole way up. I'm making these submissions because my Lord President in particular, I think, has identified on a number of occasions that there's a question here about over what period do I test these decisions? And when one asked the question, where does Lord Justice Hughes, as he then was, find the basis for rejecting CMC? He anchors it in section 69, and my simple point on that is, with the greatest respect, that cannot be the answer. And as a matter of pragmatism, the Special Commissioners thought it was the Mauritian period in relation to it. When it went to the High Court, the late, great Mr. Brennan thought that it was the snapshot for poem, albeit that's a different test to the other one. And then we get to the Court of Appeal, and the Court of Appeal focuses on the snapshot in the context of the first argument about residence at that moment. And Lord Justice Hughes says that what's sauce for the goose is sauce for the gander, so it also applies for poem. But I'm very anxious that the court doesn't think that I'm not allowed to revisit that before you. But that explains some of the difficulties that come with the temporal testing of it. For present purposes, I say I win, even if you test it by reference to the Mauritian period.
And just to be clear, or not to be clear, probably to confuse matters further, is there any reason to suppose that under Mauritian law, in Smallwood, the trust was deemed to be resident in Mauritius other than in the period during which the Mauritian trustees were in place?
I have to be very careful on that, my lord, because there isn't actually a finding of the FTT in this case. And there isn't one, I believe, in the Special Commissioner's findings in Smallwood as to what the basis period was.
Yes.
I alluded upon this yesterday regarding the evidence from the expert that was in the bundle from the FTT here about the statutory code as to what the year was in Mauritius. I better be careful not to trespass upon that.
And you're quite right, I'm going into irrelevant territory, but that wouldn't necessarily answer the point, because you might, under Mauritian law, be deemed to be resident for any part of the year, but still incur a larger liability.
Yes, that's absolutely right, my lord. And of course, in a sense, this is why I love tax law. This deals with the easy one, which is capital gains. When it gets to income tax periods, then it really gets fiddly.
Well, we're not doing that.
Oh yes, yeah. Sorry, I'm actually reminded, my lord. Of course, sorry, I should have. The point is made, as usual, very well by my learned junior on this. That, of course, for these purposes, the trustees were resident for income tax purposes in Mauritius. There wasn't a capital gains tax in Mauritius. So the basis period was not really relevant to their thing on that. And actually, there may be a finding on that, I think, which we could give you. Can I just address now for a moment the submissions that were advanced to you about, we're in the Platonist world, so I hope the court has my submission, that even if CMC were, in Platonist terms, a bad test, I would still win, because that was the test that they had in mind at the time at which the treaty was negotiated, and I'll come to swords to do some more of that in due course. But if I may, just before going to that point, just deal first of all with the questions about CMC and deal with my Lord Justice Arnold's point about the Swedish railway case. The point is made, well, CMC isn't a very good tiebreaker. And the Swedish case is identified as being the example of circumstances where the application of the CMC test may have two answers which fail to resolve it. If I could just, I don't think I need to ask you in great detail to look again at Unit and Bullock, but what I wonder if I might do is just ask you to look at one little passage of the judgment, principal judgment there, which I say sets out the ratio of the Swedish case, and which we didn't, it may have been read, but I'm not sure that the significance of it with respect was focused upon by my learned friend in his submissions. You'll find this behind, I hope, tab 8 of your bundle that we've added to.
Tab
8 of the supplemental bundle that we added to overnight.
Swedish is tab 6.
I'm going to look at Bullock.
Bullock, sorry. Yeah.
Because I say that what... So the reason I put the Egyptian case in, my lord, I have to be careful about this. One could just watch the chronology, because I'm going to make a wider point this in due course. Swedish case 1925. Egyptian case, which causes some problems following it, as we'll see from the we saw from the judgments in Unit and Bullock, is 1929. And then we get to 1960, which is Unit Construction and Bullock. Now, you read page 368 of the judgment of Lord Radcliffe there, who seeks to explain what's happening there. I believe you may have read, but I would wish to emphasise the last sentences of that paragraph.
Could you give me the page again, please?
My lord, it's page 1, I apologise, 369 of the internal case report.
Yeah.
To complicate matters, I'm afraid I haven't got the pagination of the internal bundle in my bundle.
Don't worry, 369 is good enough. Yep.
The top paragraph of it. On this basis, the 1925 decision, that's the Swedish case, is no more than a decision on that special class of case, such as I have already noticed with reference to the Union Corporation, where the facts themselves are genuinely such as not to admit of a finding that central management and control are exercised in or from any one country. There will then be only one category of exception from the principle of the De Beers case, and not an undefined second class. So, call it codification, call it standardisation or otherwise, Lord Radcliffe is trying to identify the circumstances in which De Beers will not apply, and he identifies Sweden.
Do you dispute the fundamental point, which is you can have two CMCs?
Yes, you could, my lord.
Right.
I accept that.
Well, that's the end of it, isn't it?
My lord, no. With the greatest respect, no.
So what is the point you're trying to make?
The point is, even if you could have those, that's what was agreed, and I'll make this good in a moment, between the parties in 1981. And the mere fact that in the exceptional set of circumstances in the Swedish case, it led to, it couldn't answer the question as to where it was in both places, does not mean that that wasn't the test or the standard that was applied by the parties when they agreed this treaty. And I can make that good by reference to a couple of other points, if I may, in a moment. Can I also just say that if you look back at the findings, we read them this morning.
I apologise, Mr. Rivet. I'm struggling to understand. You referred us to page 369.
Yes, my lord.
And you said it was important.
Well, it is, my lord.
But I'm failing to understand why you say it's important, given you accept that there can be two CMCs.
Because I accept that there can be two CMCs in certain limited categories of circumstance. And that is, with respect, what Lord Radcliffe is saying in his judgment. Here are the circumstances where it happens. Look back to what he says earlier in his judgment about it. If one remembers how it gets here, we read this morning. At some stages, and indeed it was the Crown who were trying to advance the proposition at some point, prior to the amendment of the statutory rules, it was saying, look, you could just read the Swedish case, if you like, as saying, look, if central management and control is in Sweden, and you happen to be incorporated in England, then you're resident in both. And that's applying two different tests. And so says the Crown, in which case I've got a lovely, easy, judicial-made test that incorporation is sufficient to make you resident for tax purposes, with a little bit extra. And Lord Radcliffe, if you remember, observes, the difficulty with it is, I don't know what the little bit extra was. I don't have the findings of fact from the special commissioners to enable me to articulate what that special bit extra was that gave on top of incorporation thing. So the closest I can get to it is to stick the Egyptian case with the Swedish case and identify that really what is happening here is that the court identified that in the particular circumstances of that case, it was possible to have a split board applying the central management and control test. But that, in those circumstances, on this basis, the House of Lords is no more than a decision on that special class of case, such as I have already noticed with reference to the Union case, where the facts themselves are genuinely such as to not admit of a finding that central management control are exercised in or from any one country. There will then only be one category of exception to it. Now, this point gets... I can sense the point against me, but in a sense, I would, with respect, submit this as endorsing my point that whilst central management and control is not perfect as a test, as has been identified by the fact that the model treaty has been amended, it's recognising that Poem itself is not a perfect test in relation to any of this. They've got rid of it for future purposes. That doesn't mean that that wasn't what they understood at the time they agreed the treaty. And if we could turn back to Smallwood, I can make that good. If one can remember the chronology I just read out. 1925, Sweden. 1929, Egypt. 1960, Unit and Bullock. One now turns to Smallwood. I'm looking at this really so at this point, I'm addressing the point against me that in our Platonist world, CNC is not a good test for Poem, irrespective of what the parties agreed in the 81 treaty. If one looks back to the reasoning of Dr. Avery Jones and Dr. Bryce, a number of points are made about the chronology of these effects. Now, the first point is, could I ask the court to bear in mind the context of the treaty we're construing? We're construing a 1981 treaty. The former treaty was that in 1947. So it was agreed between these two parties after the decision of the House of Lords in Sweden had been issued and that in Egypt had been issued. And in those circumstances, it was agreeing that it may be taken, I hope it can be taken, that the UK had in mind that it was possible in that special category of place that Lord Radcliffe subsequently identifies it as being, it was possible that central management and control could be in two places. Nevertheless, when it comes to the agreement of the terms of the 1947 treaty, look at what the parties agree. The terms resident of the UK and resident of the colony, designed as...
Sorry, which page?
Sorry, my lord, it's page 307 of the internal bundle. The terms resident of the UK and resident of the colony, defined as the colony of Mauritius and its dependencies, mean respectively any person who is resident in the United Kingdom for the purposes of UK tax and not resident in the colony for the purposes of it, and any person who is resident in the colony for the purposes of the colonial tax and not resident in the UK for the purposes of that. And a company shall be regarded as resident in the United Kingdom if its business is managed and controlled in the United Kingdom, and as resident in the colony if its business is managed and controlled in the colony. So it's not even saying, I haven't even got the link of saying central management control and PERM means the same thing. Knowing full well.
Yes, but what's the relevance of this? This is not a tiebreaker provision.
Well, my lord, with respect, I'm not sure that's right.
Well, on what basis do you say it is a tiebreaker provision?
Well, may I put it the other way around, my lord? On what basis do we know that it is not one?
But it's a definition of the term resident, and so it might well produce double residence or dual residence in a particular case.
And the treaty failed.
The treaty failed, so it's not a tiebreaker.
Yeah. But my point is, or I might be right, and that it was recognised that there was some extreme facts in which it was possible to identify that was the case. That you may have central management and control in two jurisdictions, but nevertheless they adopted this because everybody knew what it meant, and that they recognised, as is codified by Lord Radcliffe in due course, that actually it was a special set of circumstances where these two things would be finely balanced. Now, the point that may be made against me by the Lord President, the point he made in the first day is, well, nowadays it wouldn't be unusual to have a Swedish situation because of Zoom. With respect, I think we'll just have to look at the terms of De Beers of Sweden itself, because we don't actually know what the facts of what was going on in England were at that point in time, to identify the circumstances where it was incapable of reaching a single answer of central management and control, intuitively, absent video calls and things. One should be able to reach a conclusion as to where was more central, if you like. Now, the next point in relation to it is, even supposing that I'm wrong on that, and it's not a tiebreaker made in the knowledge of the effect of Sweden, what happens next is that unit construction bullock is identified, where the ratio is articulated by Lord Radcliffe, and I don't think anybody takes issue with the fact that that is what one can take out of, the height of what one can take out of the Swedish case. And with that knowledge, the United Kingdom enters into a treaty, the Model Treaty, in 1977, and its position is recorded as being that place of effective management means central management and control.
No, it doesn't say that. Show us the words that say that.
My lord.
It says the exact opposite.
Let me go back to the terms of the Model Treaty on that point.
Page 42, tab 4. That's one
great,
place.
The Model Treaty, sorry, the Model Treaty or the actual treaty? The
Well,
actual treaty.
doesn't matter. Yeah.
The actual treaty and the commentary
This is the
we
back.
are looking at
the back.
1977.
Yeah, sorry. Tab 24.
Page 651. Concerning conventions concluded by the United Kingdom which provide that a company should be regarded as resident in the state in which its business is managed and controlled, it's been made clear on the United Kingdom side that this expression means the effective management of the enterprise. Now, that is, with my respectful submission, I read that as saying this. Furthermore, one doesn't have to take it from me, as you saw from the statement of practice, and we should look at that again. That is how HMRC, for a number of years, said that they interpreted it. Furthermore, that is the position that was being advanced by the Crown for years after the issue of the Statement of Practice in 1992. My lord has my point, so I don't want to...
Indeed.
Thank you. Do I need to take the court back to that Statement of Practice?
No.
I'm grateful, my lord. So then the point about, well, CMC may fail. Well, it might do. There might be a set of circumstances where it doesn't work. As I've said, it doesn't matter. That's what they agreed. But even if it does, so does my learned friend's case. That may also fail. I query and postulate the question, how would my learned friend's case solution solve the Swedish railway case? It would find Poem was in both jurisdictions. The whole point there is it was finely balanced for CMC purposes. And this, in a sense, is why the OECD in subsequent years has been so anxious to identify that, look, actually, none of these tests is perfect. So we're just going to have you agree it yourselves, and here are some tools by which you can do it. Yeah, thank you. And indeed, I'm reminded, even in the terms of the Mauritian Treaty that was agreed in 1981, if you recall, I should turn it up now, the provisions of Article 4.2, which are dealing with individuals, there are waterfalls there, recognising that each of those particular tests, including one, the Centre of Vital Interests, may fail as a tiebreaker. And that's why you go into a targeted map procedure for those. So nobody is advancing the submission that that any of these tests are perfect. My submission is, mine is a familiar, clear case that was advanced and is identified throughout the authorities as being, putting it neutrally, at least one candidate as to what's meant by this. And certainly, as Lord Newman, did Cardinal Newman say, in a higher world it is otherwise, but here below to live is to change, and to be perfect is to have changed often.
Well, that's a nice quote. I like that.
I'm glad something's gone away. But yeah,
so did you say that's Cardinal Newman?
It's Cardinal Newman, my lord.
Thank you.
Thank you. But my point is, at its very lowest, my test is not less decisive than HMRC's. It's more decisive. Yeah. And intriguingly, one of the ways in which my learned friend identifies his test as being, well, look, this is substance over form. The whole point of the English CMC line of authorities is substance over form. That's what those cases are resolving. They are dealing with the circumstances where somebody says the brittle operation of a statutory rule or the terms of a contract between the members of a company cannot determine the meaning. You need to look at it. And what it does is, through a series of pretty mature jurisprudence from high courts, to articulate the circumstances in which management, effective management or in control, will or will not be made elsewhere. You can test it the other way around. I can test it actually by reference to my learned friend Skeleton argument, if I may, by a phrase that's put in there, which in my submission is really what I think may lie, the concern may be in this. One turns to paragraph 20, my learned friend Skeleton argument. Paragraph 20. It ignores, for example, the decision to enter into the plan to sell the shares in a tax-efficient manner by appointing Mauritius trustees and then repatriating the trust to the UK in the same year as the sale of the shares. Now, the difficulty with this, Wood and Holden, the decision to incorporate and use eulalia was part of a tax avoidance scheme. There was advice all over it. You saw the comments about what was happening from Manchester in terms of the advice that was provided, and that the corporate trustees of Eulalia had some limited decisions to make, but nonetheless they made them. If you remember the mantra that's used, a decision to rubber stamp is a decision nonetheless. And they were made in the Netherlands. What I think the case is that is attempted to argue is, rather than on the face of matters testing where the place of effective management is of trustee qua trustee, there is some penumbral mandate floating around that entitles one to have regard to the intention of a settler or somebody outside the office of a trusteeship. And to say that the quality of the decisions or otherwise, which actually fell to the trustee qua trustee, were not such as to render them the manager of the trust. But that takes me back to my point, the spooky consequences of all of this. Because settlers express ambitions as to how trustees should work every day of the week. Law firms in London, every day of the week, advise trustees offshore or onshore, and doesn't even need to test it by this, as to in what sequence or what they need to do in order to give effect to an ambition or to something which they, or otherwise. Now, that is the test that is to be applied to disturb Wooden-Holden. It's in the face of Wooden-Holden, and it's a new piece of principle that my learned friend is trying to get off the ground by reference to a construction of poem. And there's no warrant under the terms of the treaty for that. And where does it end? I know, in a sense, one has to be careful about how one puts these points. Nobody has shied away from the fact that one component of the decisions that fell in this case was that there was a CGT advantage to the appointment of the Mauritian trustees. My criticism of the First Tier Tribunal in this case, but also of my learned friend's case, is that it concertinas a whole wave of different decisions into one organic scheme. The starting point of all of this is that it's the merger of two companies and a flotation that's decided upon by the directors of the directors, not decided upon by the shareholders or otherwise. And the reason that in our skeleton argument I have placed such importance upon the content that FTT found in our case upon the quality of the decision making in relation to the ones that actually matter, trustee qua trustee, is because they are a very long way away from the findings that are made in paragraph 139 of the evidence of Miss Taha in the Smallwood case. And, my Lord, I feel out of fairness to my clients, I think your Lordship at one stage agreed with my learned friend that the fact pattern in relation to our case was similar to Smallwood. With the greatest of respect, my Lord, in fairness to my clients, it is a very, very long way away from that, because this was not the case. Smallwood was the case in which a decision was made prior to the appointment of the Mauritian trustees to sell a portfolio of liquid quoted securities on the market. That does not require a great deal of decision making to be made, other than, as the judge says, that's been the decision to sell on that day, depending upon the market price at that point in time. In our case, I didn't take you to it in opening because I had taken the court's indication that I didn't need to address you on questions of dictation and usurpation and the quality of the decisions that were made. But you'll recall that in the context of our supplementary bundle that we put into it, I included some examples of the decisions that the trustees were required to make, including, critically, the entering into the placing agreement of these shares. These are minority shareholdings in companies that were about to be floated with a PE ratio of 100% return in relation to them, in which the trustees managed to negotiate the terms of a placing agreement which absolved them of providing warranties. This is not the case of a quick trip to Mauritius and the sale of a portfolio of Hargreaves Lansdowne held stocks. And one of the things, I recognise the criticisms that were advanced yesterday about my focus upon Mr. Justice Park saying well, look, who calling the shots? I have to be careful of that language. Where was his control? Manchester or Leeds or wherever else it was. But I do ask the question in these circumstances: who is said to be managing these trustees if it's not the trustees? Is it the settler? Because he says, I think it would be a good idea for you to consider doing this because and I'd like you to consider it, and you take advice and you do so. Is it him? Or is it the advisors who manage an incredibly complicated process? And if so, where on ordinary principles, forgetting poem, does that leave everybody? Let me test it this way. Forgetting the niceties of international tax law in relation to this, if the trustees aren't making the decisions properly, aren't making the management decisions in this case, and somebody else is, what are they then? A trustee dissentort? What is their, in the case of a company, it's easy, because if somebody who is not a director of a company makes a decision in practice that, on behalf of the company, but then they become a shadow director, and we've got endless jurisprudence on that.
Not necessarily.
Okay, sorry. Well, they might do, my lords, but they might do or they might not. But the law has organised categories of that, and what I'm worried about is at what point, when the world breeds your judgment after this, will those who come after you be able to articulate, well, we must be careful here, because if we sit in Dresner's or wherever it is and we give advice that actually, if you want to float your company and merge it and to sell it in a way which minimises, forget the tax avoidance or otherwise, which just doesn't maximise the tax here in question, how do we ensure that what we are doing is not something that renders us managers of this, and with all the consequence there? In my respectful submission, our test articulates those boundaries, possibly not perfectly, but it does so in terms which I submit were precisely what the parties understood in 1977, and brings with it the benefit of 100 years of some pretty sophisticated jurisprudence. Whereas the alternative is a fight on the facts. My lords, I'm reminded, and I should pay testament to my learned junior who's been brilliant throughout this, that there is some commentary upon the use of things in the Special Commissioners about the context in which points are made in the Special Commissioner's judgment in Smallwood. I think I took you to that yesterday, so I won't take you back to it. But subject to that...
It is within, sorry, I missed the... Where is the commentary?
Oh, I'm so sorry.
Is it in the
paragraph 98.
Is it within the Special Commission?
It is, my
yes,
lord, yes.
Yeah, we did see that.
My lords, unless I can help you further, those are awesome.
Anything else? Yeah. Well, extremely grateful. Nothing further from us, Mr. Rivet. It has been a stimulating couple of days, and can I endorse what you've said about Mr. Elliott and include Mr. Dawajiwala in that, and indeed everybody who sits behind. This has been very clearly presented. It's obvious that the answer isn't easy, and as we've gone on, the clarity of the presentation has made it even more obvious that the answer isn't easy. So we are where we are. We'll reserve our judgments and circulate drafts in the usual way for you to identify the inevitable typographical errors, but not become involved in any further argument. You might submit further paragraph numbers with reference to effective management.
Thank you.
I think, and I don't think there were any other references we were waiting for. If there are...
No, it was references to the contracting state, and you gave us Article 8.1, and it's also in Article 8.2, I noticed.
Yes, there we are. Good.
So you needn't trouble with Article 8.2, we've got that one.
Right.
My lord, the one thing I didn't do was to give Lord Justice Arnold the answer to the Ottawa framework.
Oh, thank you.
My learned junior has dug this up. The 1988 Ottawa Conference was an agreement of various broad taxation principles relating to e-commerce. There we are. That's as far as we've got. I'm
Well,
sorry, my lord. I hope that's between
Yeah,
those who
well,
are...
I mean, to be fair, the question only arises because of on one level, a very sensible decision, which is you only put the extract of the document in that was relevant, and therefore didn't include the first page or so, which would no doubt have explained what they were talking about. So it's totally forgivable.
Thank you.
Resolve that cliffhanger. Thank you all very much. Thank you.
All right.